Now, I said at the beginning that I get asked this question a lot. So why is this a problem? You've got untraceable shareholders. Why is it an issue for the company? And the starting point, as you can see on the slide, is that a share gives the shareholder rights. So it's not the case that a company can simply stop paying dividends or proceed to make decisions without the missing shareholders' input simply because the company is unable to contact them. So they can't do these things and just ignore the fact that shareholder is missing. While you're out looking for those shareholders, the first thing you have to make sure you do is give your notices properly. So it's the key practical point to take away from today's webinar. You absolutely must give all notices properly. Because what you have to think about is where you've exhausted all avenues of contacting the untraceable shareholder, and and the company is aware that that shareholder can't be reached at the address in the register of members, the question that's commonly asked is, would failure of giving notice of that meeting to that shareholder invalidate your shareholder meeting? The final thing that I wanted to talk about, which is actually, again, another technical point, is whether or not you wanted to consider amending the articles in the future. So you've seen the model articles do deal with and do address having untraceable shareholders, but you may want to go further than that to make things easier if this is something that crops up a lot in practice. Okay, so the amendments I'm going to raise are just amendments that other companies have chosen to adopt.